as we've noted from a number of colleagues who follow us on this platform, that we really appreciate your input. It guides us in terms of how we then progress and deal with the matters, especially for some of the matters like the matter that we're going to deal with today. But with that, I'd like to just welcome everybody. I have welcomed the members of ELS and management and staff at NERSA, but I'd like to welcome all of the colleagues and all of the participants and those stakeholders out there that might be interested in the matter at hand. My name is Nhlanhla Kumete. I'll be chairing the meeting today. With me on the call, I'll raise the names as I see them on the platform without any. It's supposed to indicate any significance, but of course we all know that all animals are equal, but some animals are more equal. But nonetheless, I'll start with Ms. Nomfundo Maseti. She is the member primarily responsible for pipe gas. She is a member of this committee and other committees at NERSA, subcommittees and committees at NERSA. Also, on the call, I've got Mr. Tembani Pogula, who is the chairperson at NERSA, who is a member of this committee as well as other committees. But his primary role, of course, is that of chairing the energy regulator. I've also got Mr. Muzuvukile Kize, who is a member primarily responsible for petroleum pipelines. He's a member of this committee as well as the member of all of the of a number of other subcommittees, as well as a number of committees, especially one on capacity building. I've also got Advocate Nomalanga Sithole, who is the CEO at NERSA. She's a member of this committee and a member of other subcommittees, as well as the committee as well as other committees. But of course, she also has the responsibility of managing the affairs of NERSA. We will be joined slightly later by Miss Simane. I'm hoping that when she joins, we will be able to then indicate that she has joined. She's also a member of this committee and a member of other committees, but also the chairperson of the finance committee. With that, I'll then like to then take us through to agenda item number 3, which is the adoption of the agenda. Members, by show of hands, the agenda has only really got one item, which is going to be discussed in the open today. And thereafter, we will then close the meeting to discuss other internal matters. But with that, members, can I see by show of hands if we can adopt the agenda, which is really just that one item? Thank you, Mr. Pokula. Thank you, Mr. Mkhize. Thank you, Dr. Maseti. Thank you, Advocate Sithole. Thank you, members. The agenda is so adopted. Can I now then take us to the declaration of interest? On the matter that is or the declaration of interest on the agenda items that are sitting before us. Firstly, can I see if there are any verbal interests that need to be declared by show of hands, members, if anyone wants to declare verbally? Thank you, Mr. Pokula. I note your hand.
Thank you, Chair. For me, it is just to declare that I do not have pecuniary interest, but since this is a trader, I would not participate in the decision making. I would provide inputs to the submission, though. Thank you.
Thank you, Mr. Pokula. So noted. But members, can we again just complete the forms which are attached on convene and share that and share the forms with Mr. Mabunda? That also applies to the to management and staff. With that, can I then take us directly to agenda item number 5? Mr. Mkhize Jr., if you can introduce the item. Or in his absence, whoever that might have been delegated to actually do the same. Mr. Hore.
Okay. Good morning, Chair. Good morning, members. This is a submission from Greenco for the import and export license. Greenco intends to buy power and sell it to Sibanye gold mines. It also intends to trade from electricity from Zambia, from IPPs from Zambia, and it is a member of SEP, so it have got to also abide by the rules, by the SEP rules in regards to how the energy balancing is going to be done. I will let Ms. Njuku add the other details for the submission. Thank you.
Thank you, Mr. Hore.
Good morning. Thank you, through you, Chair. Good morning to the members of the public, the management, and colleagues. This is the application by Greenco Power Services for import and export of electricity. And the purpose of the submission is to request the Electricity Subcommittee to recommend to the Energy Regulator for approval. The approval of new licenses with license conditions excluding the Cochrane is delegated to the Energy Regulator. Greenco Power Services is registered according to the company laws of the Republic, and it is a whole-owned subsidiary of the African Greenco Group Limited, which is based in Zambia, where they are trading electricity through the Southern African Power Pool market. Greenco also joined the Southern African Power Pool in 2021, and they were the first members to join under the category of being a market participant. And Greenco intends to import 65 megawatts of power from Tati Solar, which is based in Botswana, and they've entered into a 5-year generation power purchase agreement. And Tati Solar is currently building a 100 megawatt solar PV generation facility there, and its commercial operation date is in 2026. The power that will be imported by Greenco is aimed at bringing more capacity in the Republic, and it will be sold to Sibanye Water. Greenco will utilize the NTCSA interconnectors as detailed in the table 4 of the RFD for the import of energy on behalf of Sibanye. All the deliveries of such power at the interconnectors will be included in the hourly schedule delivered by Greenco to Eskom under the draft system operation agreement. And the Greenco's international IPPs will therefore not require any direct contractual agreement with Eskom, as all the energy scheduling will be dealt with under the system operations agreement via the Southern African Power Pool. The applicant has also had the heads of term operation agreement as well as the balancing of energy agreement to enable the NTCSA to process their request for network access. The application was duly advertised by NESA, and the public hearing was held in July. NESA did not receive any objections following the advertisement of the application. And then during the public hearing, Eskom Holdings made the presentation in support of the import and export electricity license. So the NTSA informed NESA that they are currently processing the drafting agreements to enable and facilitate any person who wants to import and export energy into the Republic. And they will be accorded the same requirements and documentations to complete. We therefore request that the Electricity Subcommittee recommend to the Energy Regulator the issuance of the Greenco Power Service import and export license. The list of recommendations are on page 9 of 184. Thank you, Chair.
Thank you, Ms. Njoku. Members, we've got the submission before us. Any questions, comments, guidance, additions on the side? Anything that you'd like to add to guide the team on, to enhance the submission? By show of hands. Mr. Pokula?
Thank you, Chairperson. I'm even getting shy now of raising my hand because I may be accused of talking too much in these things. But with that in mind, I just want to indicate that for me, these are enhancements, and I I have no objections to the issuing of the license. I'm in support of issuing of the license. But let me start with the one 5.3 on the actual document. 5.3, we list that the application has been analyzed in terms of the technical, financial, economic, regulatory, or legal. It is fine, maybe an overreach from what the Act Section 10(2)(b) requires us to do. But even if we have the overreach, but I think we also should not leave out what the regulations want us to do. They require us to look at the administrative abilities. So it's not included there. It's not done in the RFD as well. And my recommendation would be that even when we approve, we may have to take back the RFD and still do some work on it. And then I come to the next point, 7.4. 7.4 talks about NTSA, NASA. I mean, that sentence is not clear. I don't understand it. I don't know what it means, and I don't know if it needs to be included in the document. And then we go to the RFD itself. And if we start from, I'll skip the other minor editorial things that must be done. And really, I don't understand why we are going to sit in a committee and talk about editorial stuff, but at the same time, as a committee, we can't just let submissions go through without pointing this out. And I want to urge and implore the colleagues that work on this, can you please do your work? Can you just ensure that it goes to whoever it must go to, and you clear the grammar and the spelling errors? I mean, this is not a committee for talking about spelling errors. And so on the RFD, I mean, let me leave those other issues of the spelling errors and just start on item 31. I'm not sure from 31 right up to 34 if this is necessary. We're talking about the NTSA. This is not an NTSA application. And the things that are in there, yes, they are in their application, and all we need to do is to apply them. So 31 to 34, I don't think they are necessary and required in this. And then there's also 39, where we talk about a myriad of issues. I don't understand what that is for, and maybe it can be explained, but it would be good if it's removed as well. And 46, I've settled it. 46 is also not clear for me, but really the point I want to get to is around our financial analysis. Our financial analysis should just understand that we're analyzing a licensee to import and export. And therefore, we just look at the numbers that we are given. For instance, 59, we talk about the rule of thumb states that an investor ought to do that. That's not necessarily how these import and export or trading entities work like. It's not 1 month. It's there in the PPA that you were looking at that says what are the financial requirements. So to say that there's a rule of thumb and yet the PPAs that you are saying we must note clearly define what the requirements are is not proper. The second thing around this financial analysis, I mean, we know this is going to be for 5 years. We may not have asked them for the financials for 5 years for whatever reason that we didn't ask them for. But for us to look at the financial abilities, we should have had just those 5 years of that. And I can see in the submission as well, we talk about that the annual, I think it's on 67, the annual payment will be this. I mean, it doesn't show that we are understanding what we're doing when we talk about that annual payment. These things would be escalated by a certain value, so we could at least show the 5-year financials and that we have looked at their abilities. And then we also, in some parts of this 59, we talk about beyond 59, we talk about that we don't think that this entity would be able to survive. We don't know that. We've based it by saying that when we look at this and that, that's how much it's going to be. But we also, when we've looked at the purchase price and we looked at mega flags, and yet this thing is going to be offset at Webster's losses, I think we are showing our not understanding of how the trading would be done. But having shown that, we also don't know. I mean, all we have is the heads of agreements. We don't know whether the customer, having declared that we're only seeing 21% profit, the customer may be willing to pay a premium for green power. That we don't know. And maybe we have not even asked for that information because in the heads of terms that were in the submission are not there. So my suggestion is let's stay clear from things that we don't know if we have not asked them, but indicate what we've seen from what we have asked, like having that 5-year thing, that's how they would sell, and indicate that we would then look at the pricing to the customer once that has been concluded. But I mean, I don't think there's anything that's unbecoming. And then the last one, Chairperson, allow me to just talk. The last one is really on this prudency assessment. I don't know what is this for. I don't know which part of the Act requires this, and I even don't know how can we do the assessment when we are assessing the necessity of the entity in question. We are not there to assess the necessity of the entity. They have applied. We look at their administrative, technical, and financial abilities, not their necessity. The reasonableness of the cost, I don't know how we can look at the reasonableness of the cost when we have not even don't have them. Whether the investment decision is in the best interest of both the licensee and the customer. Clearly, when they have that agreement between them, it must be in their best interest. I don't know what we are going to assess in that. And whether the decision to incur the cost is consistent with good industry practice, I don't know how we would do that. So that whole prudency assessment, I think it's not necessary and should be removed from this. And the last one, I think it's from 79 to 83, those PSA terms, I mean, we have just copied what's in the power supply agreement, but it adds no value to what we're assessing. And if we really want to assess, we can add that we think that they have the administrative powers or abilities to do this. And let me stop there for now, Chair. Thank you.
Thank you so very much, Mr. Bukola, for the much needed guidance. Madam Masset.
Thank you, Chairperson, for the opportunity. I just want to get clarification from the team, especially on the proposals that came from Eskom with regards to the connection for facilitating the trading by the applicant. I would like to get clarification, and also in terms of our approach on the issues that were raised by Eskom, one of them being the requirement to apply for connection, and also for the use of system agreement to connect to the grid on the South African side. So this must also be explained, because the delay in taking a decision on this one, or the slight delay in taking the decision on this one, was because of this issue of connection. And it should have been touched on by the team and clarify exactly whether this is something that we require as the regulator before considering the application, or to have a final decision on the application. I know that we don't have the rules that clarify what we need to consider in terms of this, but the Act must provide guidance to us on this matter. So if now we have issues of connection first, applying for connection, as well as the use of system agreement. How do we deal with those things, if that can be clarified? And the other thing that I would like to get clarity on is the issue of upfront connection charges versus this monthly use of system charges. Can we get some clarification on that? How do we align those two, and are those two necessary, or how are we supposed to sort of treat them? The upfront connection charges as well as the monthly use of system charges. I understand the monthly use of charges because it will depend on your usage, which is your service charges. But then the upfront one, can we also be clarified? What is it that will trigger the upfront charges? Can we also just clarify the issue of the reservation of capacity on the network? Do we have that in our regime for the allocation of capacity, the issue of the capacity? If that then is the case, why should we allow that? Would that not exclude others from utilizing the network? Especially because the network in this case will be an essential facility, something that is so important that everybody should be able to make use of if you you qualify for the use of the network. And again, there is an issue of capacity allocation. I'm not sure if we don't have the rules on that. But yet we talk about the reservation of capacity. Why should there be a reservation of capacity? And have we looked at the implications of the reservation of capacity from the viewpoint of exclusivity and also deterring other potential entrants from utilizing the capacity of the network? If that can be clarified for me. Thank you, Chairperson.
Thank you, Madam Massetti. I'm not sure if there are any further hands. It looks like it, but I think, colleagues, for me, you can respond to issues that you absolutely need to respond to today. However, firstly, just shooting from the hip is always a challenge. It would be useful that whatever that we respond to, that we enhance two-pager on, as well as enhancing the RFDs with responses that are actually appropriate. But I think a lot of the issues that were raised by Mr. Pukula, which really, for me, I really find them very, very useful and good guidance. And also, I mean, the issue of us focusing on the Act. The Act has got a part which is Section 10.2. that raises all of the issues, and really our assessment should be focusing on that and all other issues that are supported in terms of the Act. So, for instance, to the extent to which something goes against or supports the objects of the Act or any other relevant sections. But ideally, the guidance from Mr. Pukula, which is, I think, I'm hoping that colleagues will agree with me, good guidance as we go forward, is that the focus should be on 10.2. So there are lots of issues that have been raised around 10.2, and mine would be to say, let's get a recording of the meeting today and respond to them, not by saying noted, but actually indicating if it's something that is based on the law, to indicate what the law says. If it's not, to indicate how we've dealt with it in detail. So that would be my request. And if we need to do that pro forma financial statements, those pro forma financial statements to look at the 5 years, because it's not the presence that we understand to enhance the RFDs, that it would be useful. I'm sure Brinco would be more than willing to provide us with that pro forma, with those pro forma financials. Is something they do for a living. So they'll be able to give us this 5-year pro forma financial statements. But can I hand over back to you, Mr. Hore and Ms. Njoku? And as I'm saying, let's not respond for the sake of responding, but let's respond to those things that we need to respond to, especially to direct questions asked by Madam Maseti. But even in those, I'd really like to actually for us to provide proper, well thought out responses in writing, because all of these issues that members are raising, they're not raising for themselves, they're raising for the benefit of others as well. So if those can be responded properly, and in the two-pager, they can then be explained properly. But can I hand over back to you, Mr. Hore and Ms. Njoku, to respond to those issues that you want to respond to with the guidance I've provided? Starting with you, I guess, Mr. Hore.
Okay, thank you, Chair. I think you will do as guided. We will relook at the questions that have been raised. Then we'll respond. We'll prepare a two-pager that will address all those issues. But maybe just two things with regards to the upfront connection charges. This they relate to if you want to import or export electricity, then the network owner, you've got to also ensure that there is capacity there, and where there is no capacity, then there are also some costs that are related to the upgrade of any constraints that will be there, but will actually enhance it in the two-pager that we are going to give. I think the same applies to the reservation of capacity on our network. Once you have got a use of system agreement, it means you can't now accept maybe you can't unilaterally want to say in future you can't now transport the electricity of this licensed importer or exporter because you no longer have capacity on your network because you have taken or you have reserved capacity to other entities or importers. So I think for the orderly development, the reservation of capacity, once we have committed, once we have entered into an agreement with the exporter and the network operator, then that process you have got to also be really obeyed so that the contract, at least you have got an integrity. Otherwise, there won't be now that yeah, they won't be that that guarantee.
Yeah. Yes, may I request again? That's the reason why I was loath to just us responding off the cuff. Is that it doesn't? We need to think through those questions that have been asked to understand their impact and what exactly they mean, and also to consider any decision that NERSA or application that's been brought before NERSA and decisions that have been made in that regard, as we provide this, so that there is interlinkages between the work that we've done before and any decisions of the regulator with the responses that are provided. But before I let you to continue answer further, can I recognize Mr. Bukula and Madam Maseti after?
Thank you, Mr. Gumed. And Mr. Gumed, I think you are right. Mr. Hore is starting to answer things that are going to misalign him with some of the things that I think it would be proper if it does the proper research of how this works. The second thing that I want to point out is that this very stuff that Ms. Maseti has asked is the very stuff that should not be in this RFD. This is not about the connection of a generator. This is about an import. And if you remember when we approved ESCOM's import-export license, we never spoke about the connection of the generators, and the others. So this is the part where I say we've just overreached for no reason around what is required. But But really, to shed some light on what Ms. Massetti has asked, Ms. Massetti, these are issues that would be dealt with the generator. The fact that the colleagues have added the stuff in an import-export license about discussions and agreements that ESCOM or the grid operator from Botswana is going to have is the part that's confusing. We should not even have that. We're talking about an import-export license. But the thing about the upfront costs is that when you are going to connect onto the system, ESCOM would require you to pay certain costs that are going to be incurred because of your connection that you require, and that gets detailed in the cost estimate letter or the budget quote letter. So those upfront costs are there. And the second part around the reservation of the capacity is that once you have paid for that in that node, then yes, you are required to connect. I mean, yes, it has been a practice, and this is in nodes that do not necessarily have the constraints that we have spoken about. And in nodes that have these constraints, that's when they do the capacity allocations. But for this application, we don't need to be talking about that. That's what the generator would have. And in that connection and use of systems agreement that the generator would have with the utility that they would have, yes, then they would have a part there that says who the off-taker of their power is. And that's where we would then see Africa Green Co. And the generator will do its part. Africa Green Co will just be that, taking the power from there. It's the generator that's going to pay those. It's got nothing to do with Africa Green Co. So in essence, we should not even be having this discussion around this. Thank you, Jim.
Thank you again, Mr. Pokola, for the guidance. So I think, Tim, I saw your hand, Madam Massetti. I don't know whether you have been covered by Mr. Pokola.
Chairperson, I am covered by Mr. Pokola. I think that's why I said we need to clarify our rules around this, whether this is something that we need to consider when we are assessing the trading license. So it is very important. But I mean, we also need to discuss some of these things, perhaps, in a workshop once they have received information, if we really need to delve into that territory. But if we're comfortable that we don't need those and that we do have sufficient information for purposes of taking a decision on the trading license, then we must be able to get to that point. And I'm hoping that, Chairperson, you will be able to guide us that we are able to take the decision that is required today, especially because some of the information that the team was required to provide here, they couldn't provide it. So I'm just concerned about how we're going to be in a position to take the decision. Yes, it's not going to be the final decision. The final decision is that of the energy regulator. It's just that it's important that at the time of taking the decision, we must have all the necessary information at our disposal, which will inform us to taking the decision. So I'm hoping that you will be able to summarize that and give us comfort that we are in a position to take a decision today. And yes, it is not a final decision. The final decision will be taken by the energy regulator. Thank you very much.
Thank you, Madam Massetti. Mr. Mkiza?
Thanks, Chairperson. Seeing that these are in the main enhancements that keep us in our lane and ensure that in crafting the decision and reasons for decision document, we do a proper job, notwithstanding the fact that the decision itself might not be affected. So I would just request that instead of seeking to respond right here and now by management, they just go through all the comments that have been put forth, get the recording, enhance or upgrade the document accordingly, and then we can then work on that going forward. But I think that in terms of taking a decision, we could still take a decision today with the need for the enhancement of the document accordingly, as it is not a final decision, but going to the energy regulator for the final decision. That would be my take. But it also goes back to the issue of ensuring that we understand the rules and the perimeters within which we need to look at every kind of type of application from our side. I'll leave it at that. Thanks, Chairperson.
Thank you, Mr. Mkhize. I think for me, just to also give comfort to Madam Maseti, firstly, it was for me, if Mr. Mkhize Jr. would be so kind as to come on stream, he would agree that in my conversations with him, a lot of the issues that were raised by Mr. Bukula are raised with him in particular. I'm not sure they're raised with the whole team, but in my conversation guiding him in terms of looking at this thing that says, we have to look at this. This is the only second import-export license that we are actually looking at. Only the second one. Therefore, yes, it is understood that we are actually going through a steep learning curve. But my guidance, for instance, for him was that we can't introduce certain things on this applicant that we did not consider or did not ask to be considered when we were looking at the NTCSA import and export license. And also, we don't really know much about the presence of this particular trader. And, the trading is a very complex business by its very nature. People that are trading in the physical and people that are then trading in, and all of the derivatives that are done on that. And some people, so most people would make money from the financial trading rather than from the physical. Just maybe the physical is just you barely make a profit on that, but the rest of the profit. I mean, the point is that again, it depends on the business model of each trader. As much as in this particular case, also, this is not even about trading because the trading was actually dealt with separately. It's about import and export. That when we look at this, we should narrow our focus to just the issues pertaining to imports and exports. Yes, I understand there's a broader issue that was raised by Mr. Mkhize earlier that we still need to have, and he's raised it prior on a number of occasions before, about the rules that govern each of these areas in respect of what the Electricity Regulation Act requires of us to do. But also we need to have a framework. We need to be quite clear that when we are considering generation license, this is the framework that applies to generation licenses. When we are looking at transmission, and very soon we're going to have to look at systems operator, there's going to have to be an application applied for specifically for systems operations and for market operations. We must be clear in terms of the framework. How are we going to analyze those processes? As much as, when we're looking at the operation of a distribution facility, as well as, when we're looking at trading. That's what we need to do. And it's something that needs to be engaged with the stakeholders as well. So the stakeholders are quite clear in terms of what exactly is expected of them when they make this application. So it's something that is still missing. But having said that, we still have Section 10(2) of the Act that specifies the things that we should be looking at. We just need to be able to separate out those issues that are in respect of each license and not bring issues that are not for a particular license, bring them over into another license because they then complicate issues. So, for instance, the issue of a BQ, a budget code, when we're looking at trading licenses, is irrelevant. So all of those issues, when they're raised, we should be able to have, actually remove them, because if we include them and we can't provide answers that may then come out of that, it causes a problem. So for us, I think we've been guided. That we got very good guidance from members. Let's remove the things. Let's remove the things in the RFD that don't belong to this application. Let's bring in additional things that might be required, especially, for instance, that issue around because that particular section that talks about there is administrative thing. If we need to enhance it, let's make sure that all of the issues that are being raised in terms of Section 2 indicate if they are not applicable. And if they're not applicable, let's indicate exactly like that, not applicable. Let's not try to invert something. But I think we got very good guidance today, team. And that's not, all my request is not, let's not try to provide off the cuff responses because we're going to miss the point, and we might actually contradict some of the decisions that have been made by the energy regulator, and they may be in respect of things that are actually irrelevant for this application anyway. So my request, I think, as indicated by Mr. Mkhize as well, that a lot of what was provided today was about enhancement. Let's enhance the RFD. Let's enhance some of the issues that we have raised, the members have raised. Let's listen to the recording and provide a reason. So if we are removing it from the RFD because it is irrelevant, the 2-page I would be able to actually clarify that, to ensure that we, to make sure that we have listened to the guidance by members. And of course, let's not forget all of the grammatical errors that we still need to deal with. Those should not be there. And I think with time we will improve, but it's something that we need to invest in. We really need to invest in that process of how to eliminate all of these unnecessary errors, like in terms of numbering of tables. If there were such concerns here, the additions, the numbers that don't add up, all of those things are necessary because we all have either used Excel or used a calculator. Some numbers, if they don't add up, just makes you wonder where someone brought that number from. But my guidance today, and I'm hoping Ms. Maseti, this would assist us in actually reaching a decision, that a lot of the issues that were raised, save for the additions that needs to be, like, for instance, the 5-year pro forma financials, is not something that can be done by the team. We don't understand the Greenco's trading business that well. That it's something that we can request from so that it's the applicant that needs to assure us that, at least in their view of the coming 5 years, their business is financially viable. It's them, they need to demonstrate that. That's what the act is. It's not us demonstrating it, but the applicant must demonstrate that. So we can ask that, and I'm sure that Greenco would be more than willing to actually provide those things that are additional. But let's delete the things that don't belong in this particular application. I recognize you, Madam Maseti.
Thank you, Chairperson. Chairperson, I support what you are saying, and also the issue of the 2-pager going to the energy regulator. But I think in the decision that is being taken to the energy regulator, it is important that the aspect of the assessment of the administrative capability is something that is substantive, because it is specified in the Act, and therefore we cannot take a decision without that being mentioned, and we also satisfy ourselves that from a viewpoint of an administrative capability, Greenco has demonstrated it, and in what way did it demonstrate it? So that should be something that goes into the core of the analysis, and we must get that comfort when we go to the energy regulator. Yes, here I can support the decision just for the recommendation, because it is not the final decision. So I'm not concerned about being challenged on that. But when it goes to the energy regulator, that is a substantive issue, and it's not something that can just be in the 2-pager, but it must be in the analysis itself, because it is the requirement of the Act, and therefore it's one that we must comply with before we take the final decision, so that we had that information at our disposal at the time of taking the decision. Thank you, Chair.
Thank you, Madam Maseti. With that, members, if there is no additional additions, and I think the team has heard you, we are on a steep learning curve, especially for these licenses that we have never really dealt with before. Although this is the second one, the first one being NTCSA, but perhaps NTCSA being different in the sense that it's also been a part of ESCOM, and a lot of the activities that we are applying for, activities that they've already been undertaking But this one is different. This one is the it's going to be a first. It's going to really be a first private player in this space. So we are learning, and we're hoping that with that learning, we will actually be committing less and less errors, and we'll be getting better at the analysis as well as the presentation of that analysis. With that, members, can I then take us to the decision that is sought? With the enhancements that need to be made, both to the RFD as well as the enhancements that needs to be, or rather the recording that needs to be put in the two-page that goes to ER. Well thought out responses that will be on the two-page that will be sent to the energy regulator for the final decision. But the decision that is sought is on page 9 of 184, and if I can just read it for the record. Hopefully, if there are any repetitions of things that don't make sense, I'll be able to correct those so that the record is clear. It is requested that the Electricity Subcommittee recommend that the Energy Regulator 1 approve that Greencore Power Services Pty Limited be issued with an import and export license of electricity subject to the license condition that will be imposed in terms of section 14.1. Number 2, to note the 5-year generator power purchase agreement between Greencore Power Services and Tati Solar Pty Limited. Note the 4-year power purchase agreements, power purchase agreement heads of terms between Greencore Power Services and Sibanye Stillwater Evander Gold Mine. Note the tariff in the generator power purchase agreement between Greencore Power Services and Tati Solar Pty Limited. Note the tariff in the customer power supply agreement heads of terms between Greencore Power Services and Sibanye Stillwaters, and approve the decision and the reasons for decisions document, subject to all of the enhancements that have been indicated on this RFD. And in the event that I guess it's not ready, that perhaps that's something that may be deferred for a later decision, such that we capture those decisions properly. In fact, may I request that we actually remove 15.6, which is the approval of that document, because of the substantive changes that need to be effected on this, so that we don't rush the decision. The actual decisions in terms of how we would have, when we go to the ER, how we would have made the decisions, the issue that to be corrected to be indicated accordingly in the two-pager. They may not have been effected correctly yet in the document itself, but they need to be indicated. Then there needs to be an indication in the two-pager in terms of how those issues that are raised by members will be dealt with, and then we can deal with the decisions and the reasons for decision document at a later stage. Members, that would be my recommendation, that we strike out 6, only subject to the fact that the two-pager to ER will capture the essence of the changes that the team will effect on the reasons for decision document, that will then be taken to ER at a later stage. And with that, members, would you be comfortable to support those recommendations by show of hands? Again, noting that Mr. Bukula has indicated he will not be able to raise his hand on this one. Yeah. Thank you, Madam Aseti. Thank you, Mr. Mkhize. Advocate Stole, are you comfortable with this? Thank you, Advocate. I am still waiting for Madam Simane. I haven't seen Ms. Tembeya Simane yet on the platform, but she will indicate once she's joined. I also support, so you've got the majority decision. Thank you, members, for the guidance that's provided to the team, and also to the stakeholders out there to understand that it's not because of any lapse of judgment by staff or members of the energy regulator, but we are collectively all learning in this. But we are guided by the law, all of the decisions that we're making are actually based on the act, the objects of the act in terms of what the act is trying to achieve, but primarily looking at Section 10.2 of the Act. So all of the issues that are being raised are in respect of Section 10.2 of the Act, and only looking at issues for this particular license that are pertinent to this license. With that, I'd like to thank all the members of the public that may have joined us on the NESA platforms for your attendance, and also, as requested, if you kindly feel free to send us any areas of improvements, any concerns that you may have noted, so that we can all be learning as we proceed.